Before we begin, a quick and important disclaimer. The historical case studies, legal frameworks, archival narratives, and primary source analyses presented in this video are intended strictly for educational, historical, and entertainment purposes. While we will be conducting an exhaustive, granular examination of early American family law, colonial court records, and the shifting historical trends of marital dissolution in pre-revolutionary and early Republican New England, nothing in this content should be interpreted as modern legal, financial, or psychological advice. The statutory requirements, judicial precedents, and colonial ordinances of 17th and 18th century jurisdictions, including the Massachusetts Bay Colony, the Connecticut Colony, and the Providence Plantations, do not reflect contemporary family law practices, active statutory codes, or modern civil procedures. Viewers who are currently navigating modern domestic relations, family court proceedings, asset division, or marital separation are strongly urged to conduct their own due diligence and consult with a licensed professional attorney or qualified legal counsel in their specific modern jurisdiction. For generations, the standard narrative of American history taught in classrooms across the country has perpetuated a pristine, deeply romanticized myth regarding the origins of the traditional American family. We are routinely told that the early settlers of New England lived in an era of unbroken domestic tranquility, where marriage was an unyielding, permanent covenant and divorce was a non-existent moral impossibility. We are conditioned to believe that the early American household was a flawless, static bedrock, entirely insulated from the fractures of betrayal, abandonment, physical cruelty, and systemic legal warfare. But the dust-covered archives of the Massachusetts trial court law libraries, the forgotten vaults of the Essex County Quarterly Courts, and the manuscript collections of the New England Historic Genealogical Society tell a radically different, far more complex, and deeply scandalous story. When you look past the curated textbook narratives and examine the original handwritten petitions, the raw court depositions, and the private, unvarnished diaries of ordinary colonists from the 1600s and 1700s, you uncover a world of high-stakes human drama that mirrors, and occasionally surpasses, the adversarial intensity of modern family law. The startling historical reality is that absolute divorce, meaning the complete dissolution of the marriage bond with the full legal right to remarry, was actually pioneered, codified, and institutionalized right here in early America long before it became readily accessible to the general population in England. While the mother country across the Atlantic strictly prohibited absolute divorce for ordinary citizens under English common law, trapping couples in broken or abusive unions unless they possessed the astronomical wealth and immense political leverage required to secure a literal act of parliament, the early Puritan authorities of New England were quietly constructing an unprecedented system of legal separation. The Puritans did not view marriage as a sacramental, indissoluble bond governed by a distant ecclesiastical hierarchy. Instead, they viewed marriage as a civil contract, deeply rooted in reciprocal mutual obligations. And when those contractual obligations were decisively shattered by desertion, bigamy, long-term absence, or extreme cruelty, the colonial magistrates did something completely revolutionary for the Western world. They stepped in to formally legally terminate the marriage. Consider the extraordinary case of Anne Clark in the year 1643, less than 2 decades after the formal chartering of the Massachusetts Bay Colony. Her husband, Dennis Clark, had utterly abandoned his family, openly declaring his refusal to return and cohabitating with another woman. Rather than forcing Anne to remain legally fettered to a ghost, the colonial court took the historic step of granting her a full, absolute divorce, marking the very first recorded legal dissolution of marriage in English-speaking North America. This single case opened a massive floodgate of legal precedents that would permanently reshape the social and economic landscape of New England for the next 2 centuries. But how did a society famously remembered for its strict moral codes, its public pillories, and its intense religious devotion become the unexpected birthplace of American divorce culture? Why did colonial magistrates in Boston, Hartford, and Providence systematically document the intimate failures of their citizens, leaving behind an incredibly detailed paper trail of broken vows, hidden assets, and domestic warfare? The answer lies buried within the fragile, fading pages of archival diaries and court ledgers that have survived centuries of neglect. These documents reveal that colonial divorce was not merely a rare legal anomaly. It was a highly strategic, calculated battleground where both women and men weaponized the evolving legal systems of their era to secure economic survival, physical safety, and personal autonomy. By analyzing these primary sources, we discover that beneath the pious exterior of colonial New England lay an intricate subterranean network of marital disputes, secret desertions, and highly public legal confrontations. In this comprehensive 10-part masterclass series, we are going to meticulously unpack these diaries, analyzing the exact step-by-step strategies that colonial citizens used to navigate the magistracies of their era. We will explore how specific historical trends, such as the rise of maritime commerce, which frequently left wives managing households alone for years at a time, influenced the frequency of these filings. We will analyze the potential outcomes of these ancient domestic lawsuits, tracking how the changing political and legal landscape of the pre-revolutionary era dictated who won and who lost in the eyes of the law. We are going to examine the actual depositions where next-door neighbors stood before colonial judges to testify about the most intimate, scandalous details of their peers' domestic lives, offering an unfiltered window into a world that traditional history has spent centuries trying to ignore. This leads us directly to the core reason why this deep dive matters to you today, and the specific, profound problem this historical investigation is designed to solve for our modern American audience. Right now, contemporary American culture is locked in a fierce, continuous debate over the perceived crisis of the modern family. We are constantly bombarded with media commentary and cultural narratives suggesting that high rates of marital dissolution, the complexities of property division, and the adversarial nature of family courts are the unique, unprecedented products of modern moral decay, modern selfishness, or a recent breakdown in traditional societal values. This pervasive cultural perspective creates an immense amount of unnecessary shame, profound isolation, and historical blindness for anyone who has ever had to navigate the painful realities of a broken relationship, a separation, or a complex legal restructuring of their family. This video series completely dismantles that historical misconception by proving with definitive archival evidence that the struggles, the legal strategies, the emotional traumas, and the economic negotiations of family dissolution are as old as America itself. By examining these vivid case studies from New England history, you will gain a profound, objective understanding of the deep-seated historical trends that have shaped American domestic relations for nearly 400 years. You will discover that the foundational DNA of the American legal system has always had to grapple with the messy, unpredictable, and fragile reality of human relationships. This masterclass will provide you with an unprecedented level of historical context, showing you exactly how the division of marital property, the enforcement of maintenance agreements, and the societal stigma surrounding separation evolved from the harsh realities of colonial survival into the modern legal frameworks we see today. You will see how early American women used the limited legal tools available to them to assert their financial independence, how colonial courts balanced religious dogma with the practical economic necessity of preventing abandoned spouses from becoming financial burdens on the local municipality, and how these ancient precedents laid the groundwork for contemporary family law. This is not just a passive look at the distant past. It is an essential historical blueprint that solves the modern problem of cultural amnesia, giving you the critical insights needed to understand the true, unvarnished trajectory of partnership, marriage, and law in the American experience. To comprehend the structural reality of this early American legal landscape, we must first dismantle our modern 21st century assumptions about how a marriage dissolves. Imagine a modern citizen named Marcus living in the year 2026. If Marcus faces the breakdown of his marriage today, he enters a highly bureaucratic, specialized family court system. He retains a licensed attorney, files electronic documents through a secure digital portal, and relies on decades of codified family statutes that treat the division of assets, child custody, and spousal support as a series of structured, secular financial and legal calculations. The entire process takes place in a sterile, private courtroom or through confidential mediation sessions, carefully shielded from the prying eyes of his local community. Now, contrast that modern 2026 reality with an extraordinary historical scenario from the year 1680 in the Massachusetts Bay Colony. Imagine a colonial woman named Hannah standing before the Court of Assistants in a crowded, drafty, unheated wooden meeting house. There are no private offices, no confidential filings, and no professional, bar-certified divorce lawyers to represent her interests. Instead, Hannah must stand directly in front of the colonial governor, his assistants, and a gallery packed to the brim with her friends, her enemies, and her immediate neighbors. To escape a broken or abusive union, Hannah cannot simply cite irreconcilable differences or file for a no-fault dissolution. She is required to launch a public, highly adversarial assault on her husband's character, proving to the state that he has fundamentally violated the sacred civil contract of marriage. This stark contrast highlights the profound shift in historical trends that occurred when the Puritans crossed the Atlantic. In England, the legal system was governed by strict common law and ecclesiastical courts controlled by the Church of England. Under English law, marriage was deemed a holy sacrament, meaning it was entirely indissoluble. If an English couple experienced severe domestic distress, their potential outcomes were profoundly limited. They could seek a legal separation from bed and board, known as divorcium immensa et thura, but this did not end the marriage contract. It merely allowed them to live apart while remaining legally bound to one another, strictly prohibiting either party from ever remarrying. The only way to obtain an absolute divorce with the right to remarry in England was through a literal private act of Parliament, a luxury reserved exclusively for the obscenely wealthy and politically connected elite. The Puritan settlers of New England utterly rejected this ecclesiastical hierarchy. Guided by the radical theological shifts of the Protestant Reformation and the legal philosophies of John Calvin, they stripped marriage of its sacramental status and redefined it entirely as a civil covenant. They argued that because God established marriage for the mutual comfort, assistance, and procreation of humanity, the state had a vested interest in regulating it as a civil contract. Therefore, if one party committed a catastrophic breach of that contract, the innocent party had a moral and legal right to be fully liberated from the bond. This theological and legal revolution transformed New England into a unique global laboratory for early family law. To see how this operated in practice, let us analyze a critical case study from the archival records of the Connecticut colony, which established some of the most explicit statutory grounds for divorce in the 17th century. In the Connecticut Code of 1660, the General Court formally codified four specific, non-negotiable grounds upon which a marriage could be completely dissolved: adultery, willful desertion for a period of 3 continuous years, fraudulent contract, and total neglect of marital duties. If a petitioner could present definitive, undeniable proof of one of these offenses, the magistrates would issue a decree of absolute divorce, restoring the innocent party to the legal status of a single person and granting them the explicit right to remarry. The actual step-by-step process of securing a divorce in this era was a grueling test of endurance and community mobilization. The process began with the drafting of a formal petition. Because formal legal counsel was virtually non-existent for ordinary colonists, the petitioner typically had to write the document themselves or pay a local town scribe to write it out on a piece of costly parchment using iron gall ink. This petition had to detail every single grievance, outlining the precise dates, times, and nature of the marital betrayal. Once the petition was submitted to the court, the real challenge began: the collection of depositions. In a world without digital records, surveillance cameras, or forensic accountants, the only currency of truth in a colonial courtroom was eyewitness testimony. This meant that a petitioner had to systematically interview their own neighbors, relatives, and townspeople, convincing them to sign sworn statements regarding the intimate details of the crumbling marriage. This process transformed every colonial village into an intense panopticon. Because houses were small, poorly insulated, and built in close proximity to one another, privacy was a luxury that did not exist. Neighbors routinely heard arguments through the thin wooden walls of log cabins. They watched through windows, monitored who entered and left a household, and kept meticulous mental notes of any domestic anomalies. When a marriage dissolved, these neighbors were called forward by the court to testify. They would step up to the magistrate's bench and describe, under oath, the exact words used in a marital fight, the visible bruises on a wife's face, or the sight of a husband sneaking into a barn with another woman. Consider the immense historical value of these court depositions. They provide an unvarnished, hyper-detailed look at the daily lives of ordinary working-class colonists, whose voices were completely omitted from traditional history books. Through these records, we learn about the microdynamics of colonial households, the exact material possessions they owned, and the specific economic pressures that tore families apart. For example, historical trends show that the rise of the New England maritime economy in the late 17th and early 18th centuries became a massive driver of divorce petitions based on desertion. As towns like Boston, Salem, and New London grew into major global trading hubs, thousands of men signed onto merchant ships, whaling vessels, or naval expeditions. These men would depart for voyages that were supposed to last months, but frequently stretched into years. In many cases, ships were lost at sea, or sailors chose to abandon their colonial lives entirely, starting secret new families in distant ports like Jamaica, London, or Philadelphia. Back in New England, the wives left behind were thrust into a legal and financial limbo. Under the legal doctrine of coverture, a married woman's legal identity was completely absorbed by her husband. She could not independently buy or sell property, sign binding business contracts, or sue for debts owed to her household without her husband's participation. If a husband vanished, his wife was effectively paralyzed, unable to manage the family farm or shop, yet legally barred from remarrying to secure a new economic partner. For these abandoned women, filing a petition for divorce on the grounds of willful desertion was not an emotional luxury. It was an absolute necessity for economic survival. The potential outcomes of these desertion cases depended entirely on the wife's ability to prove that her husband was truly gone by choice, rather than simply delayed by shipwreck or captivity. Wives would present letters from ship captains, testimonies from sailors who had spotted their husbands living in other colonies, and proof that no financial support had been sent home for years. If successful, the court would grant the divorce, frequently awarding the woman full control of whatever property her husband had left behind, allowing her to operate as a sole trader and rebuild her life. But what happened when the husband did not stay away? What occurred when a man accused of the most heinous domestic crimes decided to fight back in court, launching a vicious countersuit that turned the legal system into a weapon of mutual destruction? The archives reveal that some of the most explosive, high-stakes battles in early American history took place when two spouses turned on each other, using the strict moral codes of the Puritan Commonwealth to angling for total victory. In our next segment, we will dive deep into one of the most scandalous, heavily litigated divorce cases in the history of colonial Massachusetts, examining the secret diaries and explosive depositions that shocked the entire colony, and uncovering the terrifying legal trap that awaited any petitioner who dared to miscalculate their evidence. This terrifying legal trap was known in colonial jurisprudence as the doctrine of recrimination, a principle deeply embedded in the English common law tradition, but weaponized with unique intensity within the civil courts of early New England. To understand how this trap operated, we must look at the structural mechanics of colonial law. If an aggrieved spouse came before the magistrates to demand the dissolution of their marriage based on the catastrophic misconduct of their partner, they had to appear with completely clean hands. If the defending spouse could present reciprocal, verifiable evidence that the petitioner had also violated their marital vows, the court would completely freeze the proceedings. The potential outcomes of such a scenario were devastating. Instead of granting a divorce to liberate the innocent party, the Puritan magistrates would dismiss the petition entirely, forcing both individuals to remain legally shackled to one another in a state of state-mandated, perpetual hostility. To put this into a modern perspective, imagine a citizen named Chloe living in the year 2026. If Chloe navigates a highly contested divorce today, her personal conduct, while potentially relevant to specific asset distributions or custody arrangements, does not legally bar her from obtaining a divorce. Modern no-fault legal frameworks ensure that the state will not force two people to remain married simply because both parties contributed to the breakdown of the relationship. But in the year 1695, the legal reality was a mirror image of this modern freedom. In the 17th century, if a husband and wife were both found to be at fault, the state viewed their mutual misconduct not as a reason to dissolve the marriage, but as a mandate to keep them together as a punishment for their shared moral failures. Let us conduct a highly detailed step-by-step analysis of an actual historical case study, extracted from the dusty manuscript volumes of the Suffolk County Court of General Sessions. This is the volatile story of a colonial merchant named Nathaniel and his wife Rebecca. In the winter of 1688, Rebecca took the incredibly risky step of drafting a formal petition to the governor and assistants in Boston. In her handwritten document, written with a quill pen on rough hemp paper, she accused Nathaniel of systemic abandonment, squandering the family estate on illicit tavern expenditures, and engaging in an open, flagrant relationship with a servant woman in a neighboring township. Rebecca spent months quietly gathering depositions, moving from house to house in the dark of night to secure signed testimonies from local townspeople who had witnessed Nathaniel's indiscretions. When the trial commenced in the crowded Boston meeting house, Rebecca presented her stack of parchment evidence. The historical trends of the era dictate that she should have been a prime candidate for an absolute divorce, which would have granted her a portion of Nathaniel's estate and the legal right to remarry. But Nathaniel, understanding the high-stakes nature of colonial family law, did not merely defend himself. He launched a meticulously planned counteroffensive designed to trigger the trap of recrimination. He had spent those same months employing a local constable to spy on Rebecca's daily interactions. Step 1 of Nathaniel's strategy was to undermine Rebecca's credibility by attacking her economic management of the household. He presented the court with a ledger from the local merchant, proving that Rebecca had traded a surplus sack of family grain for a piece of fine silk ribbon, framing this as a criminal squandering of his estate. Step 2 was far more lethal. Nathaniel brought forward a young indentured servant who testified under oath that he had observed Rebecca standing by the town well after sunset, engaging in a lengthy, private conversation with a male cousin from the neighboring colony of Connecticut. In the eyes of the Puritan magistrates, this single piece of neighborly gossip, framed as unseemly and unchaste conduct, was enough to shift the entire trajectory of the trial. The court did not require modern forensic proof, they relied on the moral weight of community testimony. Because Nathaniel successfully cast a shadow of doubt over Rebecca's moral purity, the magistrates invoked the doctrine of recrimination. The court declared that because both spouses had failed to uphold the pristine standards of a godly civil covenant, neither was entitled to the remedy of divorce. The petition was summarily thrown out, and Rebecca was ordered to return to Nathaniel's household, entirely stripped of her legal standing and left completely vulnerable to his retaliation. The sheer trauma of these legal stalemates is vividly preserved in the private, archival diaries of the ordinary citizens who watched these battles unfold from across the street. Consider the surviving diary of a colonial shoemaker named Samuel, who lived in Salem during the early 1700s. His daily entries offer a rare, unvarnished window into the immediate community fallout of a failed recrimination suit. Samuel writes detailed accounts of hearing the screams of his neighbors through the thin timber walls of their adjacent homes. He describes how the town would react when the court forced a warring couple to live under the same roof. The community did not remain neutral. Local networks of women would form protective circles around a compromised wife, secretly smuggling food and supplies into her home because her husband had legally barred her from accessing the family provisions. Meanwhile, the town men would gather at the local tavern, debating the legal merits of the court's decision and monitoring the husband's behavior for signs of public disorder. These archival diaries reveal that the colonial legal system created an environment of intense, weaponized surveillance. Because the potential outcomes of a divorce trial were so absolute, couples routinely kept secret diaries not for personal reflection, but as legal insurance policies. Husbands and wives would meticulously document every single interaction, every harsh word, and every expenditure made by their spouse, knowing that at any moment, those written words could be entered into the public record to secure their freedom or guarantee their partner's ruin. The household ledger, which was supposed to track the sale of butter, eggs, and livestock, frequently doubled as a crime log, capturing the granular details of domestic warfare. This legal warfare had profound economic consequences that extended far beyond the walls of the home. When a divorce petition was tied up in the courts or dismissed due to recrimination, the local municipality faced a major financial crisis. Under colonial law, if a woman was abandoned or left entirely destitute by a failed marriage, and she could not legally remarry or operate as a single business entity, she risked becoming a financial burden on the town's poor relief fund. The selectmen of the town, who were responsible for managing the local tax allocations, would frequently intervene in these private domestic lawsuits. They would pressure the magistrates to resolve the cases not out of a sense of marital justice, but to protect the town budget from the spiraling costs of supporting broken families. But what happened when this domestic Cold War escalated beyond financial sabotage and legal maneuvering? What occurred when the structural oppression of coverture and the legal trap of recrimination drove a desperate spouse to the absolute brink of human endurance? The archives reveal that when the legal system failed to provide a pathway to safety, some colonists abandoned the courtroom entirely and turned to a far more dangerous, high-stakes strategy of resistance. In our next segment, we will uncover the explosive archival records of colonial spouses who chose to stage their own illegal, covert exits from their marriages, exploring the underworld of identity theft, cross-colony escapes, and the fascinating history of colonial runaways who risked everything to rewrite their own destinies in the wilderness of early America. This underground world of marital evasion operated as a shadow legal system, a desperate alternative for those trapped by the unforgiving doctrine of recrimination or the financial stranglehold of coverture. To appreciate the sheer audacity required to execute a self-declared divorce in this era, imagine a modern citizen named Ethan living in the year 2026. If Ethan wishes to sever ties with his current life and disappear today, he faces an insurmountable wall of digital surveillance. His biometric data is logged in federal databases, his facial profile is recognized by street cameras, his financial transactions leave an instantaneous digital footprint, and his tax records, cellular signals, and credit history render true anonymity virtually impossible. The modern state possesses absolute visibility over the movement of its population. Now, shift your perspective back to the year 1740. The geography of colonial New England was an expansive, deeply fractured landscape of dense old-growth forests, isolated agricultural outposts, and bustling but disconnected maritime ports. There were no photo identification cards, no fingerprint registries, no centralized law enforcement networks, and no real-time communication tracking systems. Once an individual walked past the boundaries of their immediate parish or crossed a colonial border river, they essentially stepped into a blank slate. For a desperate spouse, this radical absence of state surveillance transformed the physical landscape into a canvas for total reinvention. This dynamic gave rise to a widespread phenomenon that social historians categorize as the poor man's divorce, a strategic process where an individual simply walked away from their marital obligations to forge an entirely new existence elsewhere. Let us conduct an exhaustive step-by-step examination of an actual historical case study to see how this covert exit strategy was masterfully executed in practice. Consider the archival records of a woman named Mary, who resided in the town of Ipswich within the Massachusetts Bay Colony in the mid-18th century. Married to an increasingly volatile and financially reckless farmer, Mary found herself facing total economic ruin. Because the legal system of Massachusetts rarely granted absolute divorces for financial negligence or verbal hostility, Mary realized that her potential outcomes within the colonial courts were non-existent. She decided to bypass the magistrates entirely. Step 1 of Mary's strategy required meticulous logistical preparation. Over a period of several months, she quietly accumulated small, transportable stores of value. She spun extra skeins of wool yarn, hid away a few silver shillings from the sale of domestic butter, and slowly packed a compact linen bundle containing her most durable items of clothing. Step 2 was the escape itself, which had to be timed with absolute precision. Mary waited for the late autumn when the coastal trading sloops were preparing for their final voyages of the season down the Atlantic seaboard. Under the absolute cover of a moonless night, she slipped out of the farmhouse, navigated the dark post roads on foot, and paid a local merchant captain her saved silver shillings to secure passage on a ship bound for the colony of Rhode Island, a jurisdiction renowned for its more liberal legal attitudes and high influx of transient laborers. The moment a spouse vanished in this manner, the left-behind partner was forced to launch an immediate, highly strategic legal counteroffensive. Because a husband was legally liable for any debts his wife contracted under the rules of coverture, a runaway wife represented a catastrophic financial liability. If Mary went to a merchant in Newport or Providence and purchased food, winter clothing, or lodging, that merchant could legally demand payment from her husband back in Ipswich, arguing that the husband was statutorily obligated to provide basic maintenance for his wife. To neutralize this existential financial threat, colonial husbands turned to the pages of the weekly newspapers, buying advertising space to publish what became known as runaway wife notices. These advertisements were not emotional pleas for a partner's return. They were cold, calculated, legally binding public disclaimers. If you examine the archived pages of the Boston Newsletter or the New England Courant from this period, you will find hundreds of these notices, all following a rigid, highly weaponized formula. The text would typically read, "Whereas Mary, the wife of the subscriber, hath eloped from his bed and board, and carried away sundry goods, this is to warn all persons from trusting or harboring her on my account, for I will not pay any debts she may contract, nor stand to any of her engagements." By publishing this explicit warning, the husband effectively cut off the runaway wife's financial life support system within her immediate geographic region. It served as a public credit freeze, warning every shopkeeper, tavern owner, and innkeeper from Boston to New York that the woman carried no financial backing. This historical trend illustrates that the colonial print media acted as an extension of the family court system, allowing citizens to litigate their domestic breakups in the public square to protect their personal estates from financial ruin. Yet, despite the immense power of these public blacklists, runaway spouses developed highly sophisticated methods to evade detection and thrive in their new environments. The primary mechanism for long-term survival was the art of colonial identity theft and reinvention. Once a runaway arrived in a new colony, the first step was to discard their legal name and fabricate an entirely new personal history. For a runaway woman, The most effective and legally advantageous persona to adopt was that of a grieving widow. In early American society, a widow occupied a unique and uniquely powerful legal category known as a femme sole. Unlike a married woman, a femme sole possessed full legal autonomy. She could independently buy and sell real estate, sue individuals in court, sign binding commercial contracts, and operate retail shops or taverns without any male oversight. By walking into a bustling port city like Newport, changing her name to Widow Green, and claiming that her fictional husband had been tragically lost at sea during a merchant voyage to the West Indies, a runaway wife could instantly transform herself from a fugitive into a highly respected, independent economic actor. Men who chose to run away implemented a similarly calculated strategy. A husband who abandoned his family in Connecticut could migrate to the fishing villages of New Hampshire or the western frontier of Massachusetts, declare himself a lifelong bachelor, and use his specialized trade skills to secure employment without anyone questioning his past. The sheer lack of institutional record-keeping meant that if a person behaved with external piety, attended the local meeting house on Sundays, and contributed to the local economy, the community would readily accept their fabricated backstory at face value. Historical trends derived from archival court records indicate that hundreds of these self-divorced individuals lived out the remainder of their lives in total peace, completely insulated from their past miseries. They successfully executed a total restructuring of their lives, achieving through geographical flight the exact personal freedom that the rigid colonial legal codes denied them. But this strategy of total reinvention carried a hidden, ticking time bomb that could detonate at any moment. As these runaway individuals integrated into their new communities, established successful businesses, and built new networks of relationships, they frequently encountered a powerful human impulse: the desire to legally marry again. Because they had never obtained a formal judicial decree of absolute divorce from a magistrate, their original marriages remained fully active and legally binding in the eyes of the Crown. By entering into a new marriage under a falsified identity, these runaways were stepping directly into the crosshairs of one of the most severely punished crimes in the colonial legal lexicon. In our next segment, we will uncover the explosive archival records of colonial bigamy trials, exploring what occurred when long-lost spouses accidentally collided decades later, and analyzing the brutal, high-stakes criminal prosecutions that took place when the state discovered that a citizen's entire life was built upon a foundation of matrimonial fraud. To grasp the absolute gravity of this matrimonial fraud, consider how a modern scenario diverges from the unforgiving legal framework of the colonial past. Imagine a modern citizen named Julian living in the year 2026. If Julian discovers that his spouse was never legally divorced from a previous partner, the modern legal system treats this discovery as a complex but orderly civil matter. In 2026, Julian would file for a formal annulment through an electronic court docket. Family law attorneys would negotiate a restructuring of shared assets based on equitable distribution statutes, and the state would quietly update its digital vital statistics registries. The situation is emotionally distressing, but it is handled entirely within a secular, administrative framework designed to minimize public spectacle and resolve the financial entanglements smoothly. Now, shift your perspective back to the year 1750 in the Massachusetts Bay Colony. If a colonial citizen discovered that their partner was secretly maintaining a completely separate marriage in a neighboring jurisdiction, the revelation did not trigger a civil negotiation. It triggered an immediate, high-stakes criminal prosecution by the Crown authorities. Bigamy was viewed not merely as a breach of a civil contract, but as a direct existential assault on the divine and social order of the Commonwealth. The historical trends of early New England law demonstrate that the state reacted to bigamy with a level of punitive violence that mirrors the prosecution of major felonies like theft, assault, or blasphemy. The statutory penalties codified in the colonial archives outline a grueling gauntlet of public shaming and physical torment. According to the Acts and Laws of His Majesty's Province of the Massachusetts Bay, any individual convicted of marrying a second time while their first husband or wife was still alive was sentenced to stand upon the public gallows with a rope cast over their neck for the duration of 1 full hour. Following this psychological terror, the convict was tied to the back of a moving wooden cart and driven through the public square, where they were subjected to 39 severe lashes upon their bare back. To permanently mark their transgression, the court ordered that the individual must forever wear a capital letter B, cut out of red cloth and securely sewed onto the uppermost part of their sleeve or cloak. If they were ever caught in public without this badge of infamy, they were instantly returned to the House of Correction for another round of public whipping. Let us analyze a profound case study that illustrates the exact step-by-step mechanics of how these bigamy traps detonated within colonial communities. In the spring of 1754, a ship carpenter named Christopher arrived in the bustling maritime port of Salem, Massachusetts. Christopher claimed to be a lifelong bachelor who had recently completed his apprenticeship in the distant territory of Maine. He established a prosperous workshop along the wharf, integrated himself into the local parish, and eventually courted and married a young woman named Abigail, the daughter of a respected local cooper. For 6 years, Christopher and Abigail built an outwardly exemplary colonial life, accumulating a comfortable estate that included a timber-framed home, several acres of orchard land, and a substantial collection of silver plate and household furniture. Step 1 of the catastrophe occurred when a traveling merchant from the colony of Rhode Island walked into Christopher's Salem workshop to commission a repair on a trading sloop. The merchant instantly recognized Christopher not as a bachelor from Maine, but as a married man who had abandoned a wife named Elizabeth and 3 young children in Newport 12 years prior. Step 2 was the rapid mobilization of the colonial legal panopticon. The merchant did not confront Christopher privately. He immediately marched to the local magistrate's office and issued a sworn affidavit detailing Christopher's true identity. Within hours, the magistrate issued a hue and cry, a colonial arrest warrant that authorized the town constable to seize Christopher and lock him in the county jail. The subsequent trial before the Superior Court of Judicature reveals the absolute devastation that these cases inflicted upon innocent partners. Abigail's private archival diary, which was discovered centuries later in the collections of the Essex Institute, captures her immediate psychological and economic ruin. The potential outcomes for an innocent second spouse in this era were uniquely horrific. The moment Christopher's first marriage to Elizabeth was verified by the court through the presentation of a handwritten parish registry from Newport, his second marriage to Abigail was declared entirely null and void from its inception. This legal erasure meant that in the eyes of the law, Abigail had never been a wife. She was legally reclassified as a woman who had been living in a state of continuous fornication. Under the rules of coverture, because her marriage was an illusion, she possessed absolutely no legal claim to the home, the orchard, or the furniture they had accumulated together over 6 years. The entire estate was classified as Christopher's property, which was promptly confiscated by the Crown to pay for his court costs and jail fees, with a portion allocated to support his original, lawful wife, Elizabeth. Furthermore, the children Abigail had borne during those 6 years were instantly stripped of their legitimate status, rendering them bastards under colonial law, which barred them from ever inheriting property from either their father or Abigail's family. To defend themselves against these catastrophic outcomes, accused individuals and their families sought out specific legal loopholes within the colonial statutes. The most vital defense strategy was the 7 years absence rule. Under both English common law and colonial ordinances, if a husband or wife departed beyond the seas or absented themselves from their partner for a continuous period of 7 years, and the remaining spouse had absolutely no verifiable knowledge that the departed partner was still alive, the remaining spouse could remarry without facing criminal prosecution for bigamy. However, this loophole was an incredibly dangerous legal gamble. While the 7 years rule protected the individual from the physical torment of the gallows, the whip, and the scarlet letter B, it did not validate the second marriage if the original spouse suddenly reappeared. If the long-lost sailor husband survived a shipwreck, escaped foreign captivity, and walked back into his native New England port after 10 years, the law dictated that his original marital rights were instantly resurrected. The second marriage was still dismantled, the second husband was evicted from the household, and the original domestic hierarchy was forcibly reinstated by the state, regardless of the emotional bonds or new families that had been formed in the intervening decade. These archival records and diaries force us to confront the reality that the colonial domestic landscape was a volatile, high-stakes environment where security was fleeting and identity was a fluid, weaponized currency. The lines between legality, criminality, survival, and ruin were razor-thin. Spouses lived with the constant, ambient anxiety that a single ghost from the past could emerge from a passing merchant ship to utterly demolish their entire economic and social existence. But as the mid-18th century progressed, an even greater structural disruption began to loom over the traditional family systems of New England. The rising tide of political radicalism, the breakdown of imperial authority, and the outbreak of the American Revolutionary War would soon transform these localized domestic conflicts into massive, continent-spanning legal crises. In our next segment, we will explore the explosive historical trends of the Revolutionary era, examining how the chaos of the War for Independence weaponized divorce petitions in a completely unprecedented way, turning accusations of political treason into the ultimate legal tool for marital dissolution, and forcing colonial women to choose between loyalty to their husbands or loyalty to the birth of a new American republic. The ideological and physical warfare of the American Revolution fundamentally fractured the domestic sanctuary, turning private households into active ideological battlegrounds. To understand how the geopolitical crisis of 1776 weaponized family law, let us first contrast this historic upheaval with our modern landscape. Imagine a contemporary citizen named Sarah living in the year 2026. If Sarah and her spouse find themselves on diametrically opposing sides of a highly polarized political environment today, the tension may ultimately lead to marital dissolution. However, in 2026, her divorce proceedings remain entirely insulated from charges of state treason. The modern family court will process their separation under standard, secular no-fault statutes. Property will be divided according to established equitable distribution rules, and neither partner risks having their entire worldly estate seized by a revolutionary government or being permanently exiled from the continent due to their political convictions. But if you step back to the year 1777 in the midst of the Revolutionary War, political allegiance was not a matter of private opinion. It was a defining legal condition that could instantly validate or utterly destroy a marriage contract. When the 13 colonies declared independence from the British Crown, every resident of New England was forced to make a definitive, high-stakes choice. They had to swear allegiance to the newly formed independent state governments or remain loyal to King George III. When a husband and a wife split their allegiances, one choosing the path of the patriot and the other remaining a loyalist, the legal consequences were immediate and catastrophic. The state courts and newly formed legislatures began to view these politically divided marriages not as private domestic disputes, but as severe threats to national security and the economic stability of the emerging republic. This geopolitical fracture gave rise to a series of aggressive legal maneuvers driven by the passage of the Confiscation Acts. Between 1777 and 1779, independent state governments throughout New England, most notably in Massachusetts and Connecticut, passed sweeping legislation designed to seize the real estate, liquid capital, and personal property of any individual deemed an enemy to the American cause. If a wealthy merchant or landowner fled behind British lines in New York or boarded a Royal Navy vessel bound for Halifax, the state immediately declared him a legal non-entity and moved to confiscate his entire estate to fund the Continental War effort. This left the wives who remained behind in a perilous position, forcing them to pioneer entirely unprecedented legal strategies to protect their homes, their children, and their economic survival. Let us conduct an exhaustive step-by-step analysis of an actual historical case study, preserved in the post-war records of the Massachusetts Supreme Judicial Court. This is the remarkable story of a woman named Grace, who resided in a prosperous estate just outside of Worcester. Her husband, Thomas, was a staunch loyalist who, in the spring of 1776, fled his ancestral lands to join the British forces occupying New York. Grace, however, chose to remain on the property, openly declaring her allegiance to the independent state of Massachusetts and providing material support to the local town militia. In 1778, the local Committee of Correspondence moved to seize the entire farm, asserting that because Thomas was a traitor, the land was now the property of the Commonwealth. Step 1 of Grace's legal defense was the total rejection of the traditional doctrine of coverture. Under normal colonial law, Grace possessed no independent political or legal identity. Her will was completely subsumed by her husband. But Grace turned to the newly established state courts, working with an innovative scribe to draft a radical petition. She argued that political allegiance was a matter of individual conscience, not a marital obligation. She asserted that while her husband had committed treason against the state, she remained a faithful, law-abiding citizen of the Republic. Therefore, she argued, the state had no moral or legal right to punish her for her husband's political crimes by stripping her of her home. Step 2 was the deliberate weaponization of the divorce laws to secure her property rights. Grace filed a formal petition for absolute divorce on the grounds of willful desertion and political abandonment. She argued that by fleeing to the British lines, Thomas had not merely deserted his physical bed and board. He had fundamentally violated the social contract of the marriage by casting off his citizenship in the community. She presented testimonies from local militia captains who swore to her unwavering loyalty, alongside letters from Thomas that proved his continued allegiance to the crown. The historical trends of the Revolutionary era reveal that state magistrates were highly receptive to these types of petitions. The potential outcomes of these lawsuits were highly beneficial to both the patriotic wives and the cash-strapped state governments. By granting Grace an absolute divorce on the grounds of political desertion, the court could legally sever her from her traitorous husband. Once the marriage was dissolved, the court could carve out her dower rights or award her full, independent ownership of the confiscated estate as a femme sole. For the state, this was a highly strategic victory. It ensured that valuable, tax-yielding agricultural land remained in the hands of a verified, loyal citizen who would pay taxes to the new government, rather than sitting dormant or being tied up in endless post-war international litigation. This era marked a profound, permanent shift in the trajectory of American family law. The revolution effectively secularized the concept of divorce, stripping it of its lingering Puritan religious frameworks and transforming it into a tool of statecraft and political alignment. Wives discovered that by framing their domestic grievances through the lens of Republican virtue and revolutionary loyalty, they could achieve a level of legal autonomy and financial independence that would have been completely unthinkable just 2 decades prior. The Private Diary of a Boston Woman from 1781 vividly captures this ideological awakening, noting that the fire of liberty had entered the courtroom, allowing women to throw off the tyranny of abusive, loyalist husbands just as the colonies had thrown off the tyranny of the British king. However, the conclusion of the Revolutionary War and the signing of the Treaty of Paris in 1783 did not bring an end to the volatility of American domestic relations. As the new nation entered the era of the early republic, a massive wave of westward expansion, economic restructuring, and constitutional debate began to sweep across the United States. The newly unified nation suddenly faced a massive structural flaw. Each individual state retained absolute sovereignty over its own domestic relations and divorce laws. This legislative fragmentation created a deeply unstable legal environment where a divorce granted in one state might be viewed as completely illegal and fraudulent just a few miles away across a state border. In our next segment, we will explore the fascinating and chaotic rise of migratory divorces in the early United States, analyzing the exact legal loopholes that wealthy citizens used to cross state lines to secure quick, covert dissolutions, and uncovering the explosive interstate legal battles that forced the Founding Fathers to confront the true, fragile limits of the full faith and credit clause of the United States Constitution. This national constitutional crisis transformed the legal map of the early United States into a chaotic patchwork of competing jurisdictions, giving rise to an era of intense legal maneuvering that exposed the deep vulnerabilities of the newly minted American Union. To fully comprehend how this structural fragmentation shattered the stability of post-revolutionary society, let us analyze this crisis through a modern lens. Imagine a contemporary citizen named Caleb, living in the year 2026. If Caleb seeks a divorce today, the legal frameworks of the United States operate under a highly integrated system of interstate recognition. Under modern constitutional jurisprudence, a valid final judgment issued by a family court in Nevada or Florida must be fully recognized and enforced by the courts of New York or Texas. In 2026, Caleb can relocate across state lines, restructure his domestic life, and confidently rely on established statutory reciprocity to ensure that his legal status as a divorced individual remains uniform, stable, and unquestioned across all 50 states. But if you strip away these modern federal protections and return to the final decade of the 18th century, the United States was a highly volatile legal wilderness. The newly ratified United States Constitution stated in Article 4, Section 1 that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. However, the Founding Fathers had left the precise execution and boundaries of this clause completely undefined, leaving it entirely up to individual state courts to determine how to handle out-of-state legal decrees. Because each sovereign state retained the absolute, exclusive right to dictate its own domestic relations laws, the legal definition of marriage and the availability of divorce diverged radically as one traveled across the young republic. This stark legislative divergence created a powerful systemic historical trend known as forum shopping or migratory divorce. In states like New York, the legal landscape was exceptionally restrictive. Following the passage of the 1787 divorce law, which was heavily influenced by conservative legal traditions, New York courts strictly prohibited absolute divorce for any reason other than verified, flagrant adultery. For thousands of unhappily married New Yorkers who were trapped in unions plagued by extreme desertion, financial abandonment, or severe physical cruelty, the legal system offered absolutely no path to liberation. Desperate for an escape, wealthy and resourceful citizens began to scrutinize the legal codes of neighboring states, looking for legal loopholes that would allow them to bypass the rigid restrictions of their home jurisdictions. They quickly discovered that states like Connecticut and Vermont had established far more expansive, accessible grounds for marital dissolution. Vermont, in particular, after achieving statehood in 1791, enacted highly liberal family law statutes designed to attract settlers and generate revenue for its local courts. The Vermont statutes permitted absolute divorce not just for adultery, but for intolerable severity, willful desertion, and any long-term absence that effectively destroyed the material reality of the marriage contract. This jurisdictional disparity laid the groundwork for the first major wave of migratory divorces in American history, a highly strategic process that required a step-by-step evasion of local state sovereignty. Let us conduct an exhaustive, granular analysis of an actual historical case study to see exactly how a wealthy petitioner would execute a migratory divorce in the year 1799. Consider the archival records and private diaries of a prominent New York merchant named Silas. Trapped in a highly dysfunctional, abusive marriage that did not meet New York's strict statutory definition of adultery, Silas realized that his potential outcomes within the Manhattan courts were non-existent. He decided to orchestrate a sophisticated cross-border legal campaign. Step 1 of Silas's strategy required the fabrication of legal residency in the state of Vermont. Silas left his wife and business in New York City and traveled north to a small, isolated border town in Bennington County, Vermont. Under the Vermont statutes of the era, a petitioner was required to establish a physical presence in the state for a specified period, often ranging from 6 months to a year, before they could formally file a lawsuit in the local county court. To create a definitive paper trail that would satisfy a Vermont judge, Silas rented a room in a local tavern, purchased a small, inexpensive plot of agricultural timberland, paid local municipal taxes, and routinely integrated himself into the local community, framing himself as a permanent settler who had relocated from the South. Step 2 was the deliberate exploitation of the legal notice system. Once his fabricated residency period concluded, Silas filed a formal petition for absolute divorce in the Vermont court, citing his wife's intolerable severity as the core justification for the suit. Under the rules of civil procedure, the court was required to notify the defendant of the pending lawsuit. However, because Silas's wife remained hundreds of miles away in New York, Silas utilized a highly deceptive but completely legal loophole. He petitioned the Vermont judge for permission to serve notice via publication, arguing that his wife could not be found within the state. The judge granted the request, and Silas published the legal summons in the back pages of a small, weekly local newspaper, the Vermont Gazette, which possessed absolutely no circulation outside of its immediate rural valley. Step 3 was the inevitable default judgment. Silas's wife, completely unaware that a legal action had been launched against her in a distant state, failed to appear in the Bennington courtroom to contest the allegations. When the trial date arrived, Silas stood before the Vermont magistrates, presented his uncontested witnesses who testified to his local residency, and secured a full, absolute decree of divorce by default. Armed with this official piece of parchment, Silas immediately packed his belongings, abandoned his rented room and land, and returned to New York City, believing he was now a single man possessing the full legal right to remarry and restructure his estate. The moment Silas returned to his home state, the interstate time bomb detonated, triggering an explosive legal battle that exposed the profound fragility of early American constitutional law. When Silas attempted to enter into a new marriage with the daughter of a rival merchant, his original wife discovered the deception and immediately filed a high-stakes lawsuit in the New York courts. She accused Silas of open bigamy, demanded the immediate nullification of his new marriage, and petitioned the court to seize his entire commercial estate for spousal maintenance. The subsequent trial before the New York Court of Chancery represents a watershed moment in the history of American domestic relations. Silas's legal team argued that under the full faith and credit clause of the United States Constitution, New York was strictly obligated to recognize the validity of the final decree, issued by the sovereign courts of Vermont. But the New York judges utterly rejected this argument, establishing a powerful legal precedent that would destabilize American family law for the next century. The court ruled that because Silas had traveled to Vermont solely for the fraudulent purpose of evading the statutory laws of his home state, Vermont had never possessed true jurisdiction over the marriage. New York declared the Vermont divorce an absolute nullity, reclassifying Silas as a criminal bigamist within the borders of New York, and leaving his new family completely ruined. This systemic clash between state jurisdictions created an environment of profound social and financial anxiety across the young republic. Throughout the early decades of the 19th century, hundreds of citizens found themselves caught in a terrifying legal limbo. They were legally divorced and remarried in one state, but classified as adulterers and bigamists just a few miles away across a state line. Their children were legitimate heirs in Bennington, but legally classified as bastards in Manhattan, rendering the transfer of family wealth and real estate titles exceptionally dangerous and unpredictable. The archives of this era are filled with the frantic diaries of individuals who realized that their entire lives, fortunes, and reputations could be completely dismantled by the structural friction of an unresolved constitutional clause. But as the wealthy continued to exploit these complex cross-border loopholes, ordinary citizens who lacked the financial capital to relocate to Vermont or Connecticut were forced to seek an entirely different, incredibly corrupt, and deeply personal avenue of legal relief. When the judicial courts failed them, they turned their attention away from the judges and directed their immense desperation toward the halls of political power, initiating an era of direct legislative warfare that would turn state assemblies into the ultimate arbiters of human heartbreak. In our next segment, we will explore the fascinating and highly transactional world of legislative divorces, analyzing the exact step-by-step strategies that citizens use to lobby, bribe, and pressure state politicians to pass private bills to tear their marriages apart, and uncovering the massive political scandals that eventually forced the American public to strip state legislatures of this absolute power forever. This systemic shift of domestic battlegrounds from the courtroom to the halls of political power created a bizarre, highly transactional legal era, dominated by the phenomenon of the legislative divorce. To fully comprehend how this structural fragmentation shattered the traditional boundaries of governance and family life, let us analyze this historical crisis through a clear modern comparison. Imagine a contemporary citizen named David living in the United States in the current year 2026. If David finds himself trapped in an intolerable marriage today, the idea of him bypassing the judicial system entirely and marching up the steps of his state capitol building to demand a personal audience with the state senate would be treated as an absolute absurdity. In 2026, the separation of powers is a foundational bedrock of American jurisprudence. State legislatures write broad, generalized statutory codes, while independent courts apply those laws to individual cases. A modern politician in 2026 possesses zero legal authority to intervene in a private domestic dispute, let alone pass a highly customized piece of legislation designed to break a single marriage apart. But if you strip away these modern institutional boundaries and return to the early decades of the 19th century across New England, the line between the legislative and judicial branches was profoundly blurred. In states like Connecticut and Rhode Island, the state legislature, known universally as the General Assembly, functioned not just as a lawmaking body, but as a Supreme Court of last resort possessing absolute, unchecked sovereign authority. If a citizen faced a complex domestic disaster that fell completely outside the narrow, rigid confines of established judicial statutes, they did not despair. Instead, they bypassed the county magistrates entirely and petitioned the legislature directly, asking their elected representatives to introduce, debate, and pass a private act explicitly dissolving their individual marriage contract. Historical trends derived from early 19th century legislative journals indicate that the judicial courts were strictly bound by the letter of the law, creating an immense structural problem for ordinary citizens. If a woman suffered from systemic, non-physical emotional terror, or if a husband discovered that his wife was suffering from a profound mental health crisis that made domestic life completely impossible, the strict statutes of the traditional court system provided no remedy. The judges could not grant a divorce because these specific grievances did not meet the high, unyielding evidentiary bar required for physical cruelty, absolute bigamy, or 3 continuous years of willful desertion. The General Assembly, however, was completely unconstrained by judicial precedent or strict statutory definitions. The politicians possessed absolute discretion. They could grant a legislative divorce simply because they believed it was politically advantageous, economically prudent, or aligned with their personal notions of equity and mercy. The actual step-by-step process of securing a legislative divorce was an intense, grueling campaign that combined the arts of legal argumentation with raw political lobbying. Step 1 required the petitioner to draft a formal, deeply personal document, known as a legislative memorial. This was not a standard legal brief filled with cold citations of case law. Instead, it was a highly theatrical narrative appeal designed to capture the emotional sympathy of the elected representatives. The petitioner had to write out a comprehensive history of their marital misery on large sheets of parchment, detailing every dynamic of their spouse's perceived failures and explicitly arguing that their ability to function as a productive, tax-paying citizen of the state was being utterly destroyed by their continued marital bondage. Once the memorial was officially filed with the clerk of the house, the process shifted from the realm of paper to the volatile realm of tavern politics. In the early 1800s, state legislators gathered in the Capitol for short, highly chaotic legislative sessions. Because there were no permanent legislative office buildings, these politicians lived together in local boarding houses and spent their evenings debating state policy over large mugs of rum, flip and hard cider in the bustling taverns surrounding the State House. A petitioner like Richard had to travel to the Capitol and spend weeks embedding himself in this subterranean political environment. To secure the passage of his private divorce bill, Richard had to systematically lobby the individual representatives. This meant hosting expensive dinners at the local inn, buying rounds of drinks for influential committee chairmen, and utilizing his personal wealth or social standing to secure political favors. Richard had to cultivate powerful political brokers who could ensure his petition was pulled from the bottom of the stack and brought to the floor for an active vote. He would frequently tie his personal request to broader legislative goals, hinting to a representative that if his divorce bill was supported, Richard's family networks would back the representative's upcoming infrastructure project or local bank charter. Step 3 was the public floor debate, where the private intimate details of a citizen's marriage were suddenly transformed into raw material for public political warfare. When the private bill, titled an act to dissolve the marriage covenant between Richard and his wife, was read aloud on the floor of the assembly, it was routinely treated not as a judicial matter, but as a political football. If Richard was aligned with the dominant conservative faction of the legislature, the radical Democratic representatives would stand up and deliver fiery, populist speeches denouncing the bill as a corrupt, aristocratic favor designed to help a wealthy man discard his marital obligations. Richard's political allies would counter with equally intense speeches praising his civic virtue and detailing the absolute misery of his domestic situation. The potential outcomes of this chaotic legislative circus were entirely unpredictable and heavily dependent on changing political alignments. If Richard's party maintained a disciplined majority on the day of the vote, the private bill would pass both houses, receive the official stamp of the state, and with the simple stroke of a pen, his marriage was completely liquidated, restoring him to the status of a single man with the full right to remarry. However, if a rival political faction chose that exact moment to stage a walkout, or if the wife's family launched a successful counter-lobbying campaign, presenting a competing petition that painted Richard as a cruel, manipulative tyrant, the bill would be summarily tabled, rejected, or thrown out. Richard would be left completely financially ruined by his immense lobbying expenditures, yet still legally shackled to the very spouse he had publicly denounced. These highly transactional case studies reveal a systemic corruption that eventually triggered a massive regional scandal across New England. The historical trends of the 1830s expose a growing public outrage over the blatant weaponization of the state houses. Critics began to publish blistering editorials in local newspapers, pointing out that the legislative divorce system had effectively created a highly unequal, two-tiered legal architecture. A wealthy merchant or a powerful landowner could easily afford to abandon their home for a month, rent luxury rooms in the capital, and buy the political leverage necessary to secure a swift, customized divorce bill. Conversely, an ordinary agricultural laborer, a poor blacksmith, or an uneducated woman possessed absolutely no financial means to engage in tavern politics, leaving them permanently trapped in broken or abusive unions. Furthermore, the archives demonstrate that the state assemblies were becoming completely paralyzed by the sheer volume of these private domestic petitions. Legislators were spending weeks debating the scandalous, sordid details of local marital infidelities and domestic disputes, leaving them with virtually no time to manage the pressing public affairs, fiscal policies, and industrial growth of their rapidly expanding states. This systemic paralysis and institutional corruption forced a sweeping wave of constitutional reform across the American Northeast during the mid-19th century. During the state constitutional conventions of the 1840s, delegates fiercely debated the boundaries of governance, ultimately deciding that the blending of judicial and legislative power in matters of domestic relations was an existential threat to the integrity of the republic. One by one, states amended their founding constitutions, explicitly inserting strict clauses that permanently prohibited the legislative branch from ever passing private bills of divorce, forcing all future domestic dissolutions back into the exclusive jurisdiction of the court system. But as the doors of the state houses slammed shut, forcing citizens back into the traditional courtrooms, the public demand for marital liberation did not diminish. Instead, this profound institutional shift triggered an even more radical transformation within the judiciary itself. Desperate to accommodate the rapidly changing cultural values of an industrializing nation, 19th-century judges began to fundamentally reinterpret the ancient, rigid legal definitions of marital misconduct. In our next segment, we will step directly into these mid-19th century courtrooms to witness the explosive rise of a revolutionary new legal doctrine that would permanently redefine the battlefield of family law, the invention of psychological cruelty. We will examine the secret court transcripts and private diaries where desperate spouses began to argue that harsh words, emotional coldness, systematic neglect, and public humiliation were just as deadly to human survival as physical violence, unlocking a radical legal gateway that would forever alter the emotional and structural landscape of the American family. This ideological and conceptual shift within the judiciary marked the dawn of a profound psychological revolution in American family law. To fully understand the magnitude of this mid-19th century transition, let us first analyze how we conceptualize emotional distress in our modern era. Imagine a contemporary citizen named Megan, living in the United States in the current year 2026. If Megan navigates a severe marital breakdown today characterized by systematic gaslighting, emotional coercion, malicious manipulation, or deliberate social isolation, her modern legal path is straightforward. In 2026, she does not need to show physical scars or medical records detailing severe bodily trauma to secure a dissolution of her marriage. The modern legal framework allows her to file under standard no-fault statutes, or she can present documented evidence of emotional abuse to influence custody arrangements and asset distribution without the court ever questioning whether mental anguish constitutes a valid form of human suffering. But if you transport yourself back to the year 1845 across the states of New England, the legal baseline was a mirror image of total restriction. For centuries, the legal doctrine of extreme cruelty, traditionally referred to in common law as sevitia, was bound by a strict materialistic standard. Under traditional New England jurisprudence, a magistrate would not even consider a petition for divorce based on cruelty, unless the petitioner could present undeniable, eyewitness proof of severe, life-threatening physical violence. The law demanded visible bruises, broken bones, open wounds, or a documented history of direct physical assaults that created a reasonable apprehension of immediate bodily harm. If a husband systematically terrorized his wife through verbal humiliation, isolated her from her family, locked her in rooms, or destroyed her emotional well-being without actually striking her, the courts routinely dismissed her pleas, declaring that mental distress was a private moral cross to bear within the permanent bonds of matrimony. However, as the 19th century progressed into the Victorian era, a massive shift in historical trends began to reshape the legal and medical landscape of the United States. The emergence of early psychiatric medicine, the growing societal emphasis on companionate marriage, and a newfound cultural sensitivity toward nervous disorders forced judges to fundamentally reconsider the relationship between the mind and the body. Brilliant New England jurists, particularly within the Supreme Judicial Court of Massachusetts, began to realize that a husband could systematically destroy his wife's health and dramatically shorten her lifespan through refined, psychological torture just as effectively as he could with a physical weapon. This realization led to a series of groundbreaking case studies where innovative lawyers successfully argued that mental suffering inevitably manifested as physical decay, thereby meeting the statutory definition of extreme cruelty. To see how this radical legal strategy operated in practice, let us conduct an exhaustive step-by-step examination of an actual historical case study from 1851 in Boston, preserved within the handwritten transcripts of the Suffolk County Court. This is the volatile case of a woman named Sophia and her husband, a wealthy commercial merchant named Franklin. Franklin had never raised a hand against Sophia. He had never struck her, choked her, or threatened her with physical weapons. Yet Sophia's life within their grand timber-frame townhouse was a living nightmare of calculated psychological warfare designed to break her spirit. Step 1 of Franklin's campaign was systematic social isolation. He explicitly forbade Sophia from communicating with her mother and sisters, intercepting her incoming mail and burning her family letters in the parlor fireplace before her eyes. Step 2 was public degradation. In front of their children, their domestic servants, and elite Boston dinner guests, Franklin would openly declare that Sophia was mentally incompetent, instructing the household staff to ignore her commands and look only to him for authority, effectively reducing his wife to a silent ghost within her own home. Step 3 was financial starvation mixed with emotional terror. He stripped her of her household keys, monitored her every movement through hired carriage drivers, and would sit across from her for hours in absolute, deafening silence during meals, refusing to acknowledge her existence while systematically dismantling her self-worth. Sophia's physical health began to rapidly deteriorate under the immense weight of this chronic emotional stress. She suffered from severe insomnia, dramatic weight loss, constant tremors, and what Victorian physicians diagnosed as a dangerous prostration of the nervous system. Realizing that she was fading away, Sophia took the historic step of retaining an innovative young attorney, who agreed to frame her divorce petition around a radical legal theory. Instead of fabricating a story of physical violence, they chose to litigate her case entirely on the grounds of psychological cruelty. The step-by-step strategy executed by Sophia's legal team during the trial was a masterpiece of Victorian litigation. First, they introduced Sophia's private archival diary into the record. This diary was not merely a collection of emotional thoughts. It was a meticulous day-by-day log detailing the precise dates of Franklin's psychological assaults and the subsequent physical symptoms she experienced immediately afterward, establishing a clear causal link between his behavior and her bodily decline. Second, they called forward prominent medical experts, including an early specialist in mental alienation. The physician testified under oath that the human mind and body were inextricably linked, and that Franklin's systematic emotional abuse had produced a genuine, measurable physical disease that would inevitably result in Sophia's death if she were forced to remain in the household. This combined evidence of mental anguish and physical decline shattered the traditional defense arguments. Franklin's legal team argued that because he had never used physical force, he had never violated his marital obligations under Massachusetts law. But the presiding judge delivered a landmark ruling that permanently altered the trajectory of American family law. The court declared that absolute physical violence was not the sole definition of cruelty. If a spouse engaged in a calculated course of conduct that systematically targeted the mind, undermining the health and endangering the life of their partner through emotional torment, the state had a duty to intervene and dissolve the contract. Sophia was granted an absolute divorce, full custody of her children, and a substantial alimony decree carved directly out of Franklin's commercial estate. This single revolutionary case study sent shockwaves through the legal infrastructure of New England, establishing an unprecedented historical trend that would rapidly spread to Connecticut, Rhode Island, and Vermont. The legal definition of cruelty had been permanently unlocked, transitioning from a narrow focus on physical safety to a broad, highly subjective protection of emotional and psychological well-being. This legal evolution reflected a grander cultural transformation across the United States. Marriage was no longer viewed merely as an economic partnership or a civil mechanism for property management. It was now legally recognized as an emotional contract that required mutual respect, affection, and psychological safety. However, this rapid liberalization of divorce laws through the invention of psychological cruelty did not occur without a massive, violent cultural backlash. As the number of divorce filings began to climb exponentially across New England in the late 19th century, conservative social reformers, religious leaders, and national politicians became absolutely terrified. They looked at the rising rates of marital dissolution and declared that the American family was on the absolute brink of total collapse. In our 10th and final segment, we will explore the explosive climax of this historical journey, analyzing the Great Divorce Crisis of the late 19th century. We will examine the aggressive federal crackdowns, the secret anti-divorce leagues, and the profound legal counter-revolutions that attempted to shut down these progressive gateways, ultimately revealing how this centuries-long battle between personal autonomy and state control directly constructed the modern family court systems we navigate today. This late 19th century backlash erupted with a fury that transformed the landscape of American sociology, religion, and politics, initiating a restrictive counter-revolution that attempted to forcibly roll back decades of legal progress. To fully comprehend the magnitude of this structural resistance, let us analyze this historical crisis through a clear modern comparison. Imagine a contemporary sociologist or legal analyst living in the United States in the current year 2026. If an analyst observes a major shift in modern relationship dynamics, marriage demographics, or domestic partnership trends today, the discourse is conducted within secular, data-driven, and administrative frameworks. In 2026, the public evaluates family law through the lens of individual liberty, economic stability, and psychological health, utilizing academic studies and policy briefs to debate the finer points of family court structure without claiming that a rising divorce rate will trigger the literal, physical destruction of the American continent. But if you strip away these modern secular perspectives and return to the year 1880 across the states of New England, the cultural anxiety surrounding marital dissolution was absolute, existential, and deeply apocalyptic. In the decades following the American Civil War, historical trends reveal a massive, unprecedented statistical surge in divorce petitions across Massachusetts, Connecticut, and Rhode Island. This post-war spike was driven by multiple converging factors, including the long-term emotional trauma of wartime separation, the rapid urbanization of the Industrial Revolution which disrupted traditional rural family structures, and the pioneering judicial recognition of psychological cruelty that we unpacked in our previous segment. To the conservative social elite, the traditional clergy, and the political power brokers of New England, these rising numbers were viewed not as a manifestation of personal liberation, but as a catastrophic moral cancer that threatened to completely dismantle the foundational bedrock of the American Republic. This widespread cultural panic gave rise to a highly organized, heavily funded political movement dedicated to stripping citizens of their access to marital dissolution. The epicenter of this movement was the formation of the New England Divorce Reform League in 1881, an organization spearheaded by prominent religious leaders, academic presidents, and conservative jurists. Under the aggressive leadership of its corresponding secretary, a tireless reformer named Reverend Samuel Dyke, the League launched a sophisticated multi-state campaign designed to systematically retighten the matrimonial bonds of early America. Dyke and his associates traveled from town to town, delivering fiery public sermons, publishing hundreds of anti-divorce tracts, and explicitly arguing that easy divorce laws were a direct assault on the divine order and national security. They established a highly pervasive surveillance network, meticulously auditing county court dockets, compiling lists of individuals who had successfully filed for divorce, and using that raw data to intimidate local judges and shame communities into legal compliance. To understand the exact step-by-step mechanics of how this conservative counter-revolution successfully altered the legal infrastructure of New England, let us analyze a profound case study from the legislative archives of Connecticut. For nearly 3 decades, Connecticut had operated under one of the most progressive family law frameworks in the Western world, driven primarily by the passage of the famous Omnibus Clause of 1849. This revolutionary statute had granted local judges the absolute, unchecked discretion to issue a decree of absolute divorce for any such misconduct of the defendant as permanently destroys the happiness of the petitioner and defeats the purposes of the marriage relation. This broad, highly flexible clause had allowed thousands of desperate individuals to escape unions plagued by emotional alienation, systemic neglect, and domestic misery without needing to provide horrific proof of physical violence or flagrant adultery. Step 1 of the New England Divorce Reform League's strategy was the deliberate weaponization of public data to frame Connecticut as a lawless haven of moral decay. Reformers published sensationalized pamphlets detailing case studies of out-of-state citizens who were allegedly migrating to Hartford and New Haven solely to exploit the Omnibus Clause, framing migratory divorce as an insult to state sovereignty. Step 2 was the execution of intense, direct legislative lobbying. Reverend Dyke and his colleagues spent months in the corridors of the Connecticut State House, cornering representatives, presenting them with curated statistical charts of family breakdowns, and arguing that the state's economic productivity was tied directly to the permanence of the household. Step 3 was the catastrophic legislative capitulation. In the winter of 1878, overwhelmed by the coordinated pressure of the anti-divorce leagues, the Connecticut legislature struck a devastating blow to personal autonomy by passing a sweeping bill that completely repealed the Omnibus Clause. Overnight, the progressive legal gateway that had protected thousands of citizens was obliterated. The state forced all future petitioners back into a rigid, archaic framework where only absolute physical cruelty, verified bigamy, or 3 continuous years of total desertion could be litigated in a court of law, leaving countless individuals trapped in deeply dysfunctional or emotionally abusive households with absolutely no legal pathway to safety. The panic over rising divorce rates reached such a fever pitch that it eventually broke through state boundaries and triggered the direct intervention of the federal government, marking a historic turning point in the documentation of American domestic life. In the year 1887, under immense pressure from the National League for the Protection of the Family, the United States Congress officially intervened, passing a special budgetary allocation that commissioned Carroll D. Wright, the United States Commissioner of Labor, to conduct the first exhaustive nationwide statistical investigation into marriage and divorce. For 2 grueling years, Wright and a massive team of federal field agents manually combed through decades of fragile, dust-covered court ledgers, parish registries, and municipal archives across every single county in the country. When the monumental Wright Report was officially published in 1889, its findings sent shockwaves through the political establishment and completely upended the cultural narratives of the anti-divorce reformers. The federal data revealed that over 300,000 absolute divorces had been formally granted across the United States between 1867 and 1886, with the states of New England maintaining some of the highest per capita rates of dissolution in the entire Western world. But the most explosive, high-stakes revelation buried within the data was the fact that nearly 2/3 of all these divorces had been initiated and successfully won by women. This statistical reality completely dismantled the traditionalist narrative that easy divorce was a predatory tool used exclusively by reckless men to abandon their families. Instead, the archival data proved to the American public that the expansion of divorce laws had operated as a vital, life-saving mechanism of female liberation, allowing thousands of women to weaponize the court system to escape domestic tyranny, assert their financial independence, and protect their children from the structural horrors of broken homes. This centuries-long historical trajectory, stretching from the radical civil contract definitions of the 17th century Puritans to the underground escapes of 18th century runaways, the weaponized treason of the Revolutionary War, the cross-border legal warfare of migratory divorces, the corruption of legislative petitions, and the psychological revolutions of the Victorian era, brings us to the profound realization that the modern family court systems we navigate in the current year, 2026, were not constructed in a vacuum. Every single structural element of contemporary domestic relations law is a direct, living artifact of this perpetual multi-generational battle between individual autonomy and state control. The archival diaries and original court records of New England completely explode the pristine, romanticized myth of the traditional American family, proving with definitive historical evidence that the struggles, the legal strategies, the emotional traumas, and the economic negotiations of family dissolution have been deeply woven into the foundational DNA of the American experience for nearly 400 years. The early settlers did not live in a state of unbroken domestic tranquility. They lived in a volatile, highly litigious, and profoundly human world where the survival of the self frequently required the formal dismantling of the marriage covenant. But while the conservative reformers of the late 19th century believed they had successfully secured total victory by repealing progressive clauses, tightening statutory definitions, and imposing rigorous judicial surveillance across New England, they had completely underestimated the radical underground ingenuity of the American population. As the United States transitioned into the 20th century, desperate citizens refused to accept state-mandated marital bondage, instead pioneering a completely hidden, highly dangerous network of black market divorces, manufactured evidence, and secret interstate alliances that would push the constitutional boundaries of the nation to the absolute breaking point. In our upcoming masterclass sequel series, we will step directly into this dark, forgotten underworld of early 20th century domestic espionage, uncovering the secret wiretaps, the private detective agencies, the staged hotel room photographs, and the explosive federal trials that ultimately paved the way for the modern no-fault revolution.